Hello, everybody. Welcome to 2022. My name is Patricia Aaliyah. I'm from Aaliyah Associates, and thanks for joining us for CondoWise, our learning series. We're at session number 16, and it's a new beginning and a year in review. So we actually are going back to the future in some ways. We wanted to confirm that you appreciate that this is free and open to the public. Registration is not required, so please share with your fellow board members, your managers. But because every condominium is unique, the advice provided in our sessions is of a general nature and is not legal advice. So we recommend that you consult with your condominium corporation lawyer always. Next slide, please. I'm happy to be joined by Julia White, Jonathan Wright, and Shannon Penny from our team, who will provide us with a variety of perspectives. And I think you're going to find it really interesting today. I know I am, especially on the COVID pandemic update. Next slide, please. So jumping into the new year, we really have to think about where we are today. I have no idea where 2 years have gone, but humanity in condominiums has been busy, and not just with the pandemic. Although that has added a distinct flavor to 2021, with the phenomena of transitioning from shutdown to partially opening. In 2021, we saw the introduction of vaccinations and a return to a hybrid version of normal life, with the threat of variants and closures again. We saw the impact of working from home. We felt the impact of the shift of medical resources from non-elective matters to COVID. We felt inflationary pressures and have experienced supply delays, which have impacted our projects at the condos. But how did we fare in 2021? Well, I think I'm glad I'm still standing and I'm ready for 2022. Next slide, please. So Shannon, John, Julia, please give us an update on the pandemic past and where we're going in the future.
Thanks, Patricia. So as of January 5th, in response to the rapidly spreading Omicron variant, Ontario returned to a modified step 2 of its reopening plan, resulting in the closure of indoor dining, gyms, theatres, and reinstating lower capacity limits in most other indoor and outdoor settings. Social gatherings and organised public events limits were reduced to 5 people indoors and 10 people outdoors. Ontario Regulation 26320 provides that all indoor sport and recreational facilities, including gyms, must close. However, a facility can, but is not required to open its facilities for the purpose of allowing an individual with a disability to use them. So what does this mean for condominiums? So condominium boards can hold board meetings face-to-face indoors, providing that there are no more than 5 attendees. However, given the high transmission rate of the Omicron variant, it would be wise for all board meetings at this time to continue to be held virtually, and all owners' meetings must also continue to be held virtual. The current restrictions were expected to be in place until January 26th. However, Premier Ford announced the province's plan this morning that will see a gradual lift of restrictions beginning January 31st and continuing through February. So on January 31st, businesses, including gyms and restaurants offering indoor dining, will be permitted to reopen again with 50% capacity. The government added that the restrictions will be readdressed on February 21st, and providing trends remain stable, we will move into the next step where further restrictions will be eased. Going back to the current regulation, there has been an ongoing debate within the condominium industry as to whether it does in fact apply to condominiums, which Julia and I will be discussing next. Next slide, please. Over to you, Julia.
Thanks, Shannon. So since the announcement on January 5th, when Ontario returned to a modified step 2 of its reopening plan, there's been an ongoing debate within the industry as to whether Ontario Regulation 26320, which mandates the closures and capacity limits, actually applies to condos. On January 7th, the Ontario Ministry of Health confirmed that this regulation does not apply to residential condos because they're private residences. The ministry advised that all facilities providing indoor sports and recreational fitness activities, such as gyms and swimming pools, within condos can remain open. Despite this statement, the industry remains divided as to whether the Ministry of Health is correct in their interpretation of the legislation. We also question whether the ministry has the authority to make such an interpretation. In the event that the legislation does not apply to condos, boards still have the discretion to decide whether to adopt measures that are more restrictive and decide to close their indoor recreational amenities. In our most recent bulletin posted on our website, we did a deep dive into this regulation and concluded that, in our opinion, the regulation does apply to condos. We're going to take you through a quick overview of our analysis, starting with the definition of a place under the regulation. So I'm going to turn it over to Shannon now to get us started.
Thanks, Julia. So OREG 26320 states that each person responsible for a business or place or part of a business or place that is required to be closed shall ensure that it is closed in accordance with Schedule 2 of the regulation. There is no definition of a place in this regulation, which has contributed to the confusion in the industry as to whether the legislation does in fact apply to condominiums, and specifically whether condominiums are considered a place. In the previous regulation, specifically Ontario Regulation 57220, it provided that a condominium building was an example of a place. However, this provision was only with respect to organised public events and social gatherings. The limited guidance of the previous regulation has since been amended, and the new Ontario Regulation 26320 does not provide any examples of what should be considered a place, and now leaves the definition of place open to interpretation. A broad and logical interpretation of the legislation would suggest that a residential condominium is a place. However, this is still up for debate in the industry. To add even further to the confusion, Schedule 2, Section 5 of Ontario Regulation 26320 provides that businesses providing short-term rental accommodations must close any indoor pools, indoor fitness centres, and any other indoor recreational facilities. Many condominiums have short-term rentals operating from individual units. However, it is unclear whether this section of the legislation applies to such rental units or the condominium building as a whole. Arguably, the legislation implies that in buildings where there are short-term rentals, all specified amenities must close. On the other hand, the condominium itself is not a building operating all units as short-term rentals. While the regulation provides that the restrictions are limited to businesses, we do question why the government would carve out a lesser standard for some types of short-term accommodations, but not others, such as those operating within residential condominium buildings. This does not make sense when the intended purpose of the legislation is to implement restrictions to reduce the transmission of the virus. So Julia, what about recreational facilities in condominiums?
Thanks, Shannon. So next in our analysis, we looked at Section 19, Schedule 2 of the regulation, which deals with indoor sports and recreational fitness activities. This section refers only to facilities instead of a business or place, as Shannon just discussed. So the government decided they apparently didn't need to include a definition of facility, so this too has been left open for interpretation. The plain word dictionary definition of a facility is something that is built, installed, or established to serve a particular purpose. So we would argue that the recreational amenities in a condo building, which were installed or established for a specific purpose, for example, a gym for the purpose of physical exercise or training, do fall under the definition of a facility under the legislation. So we've decided to take a logical approach to reviewing the legislation. We don't understand why, based on the definition of a facility in the dictionary, this wouldn't apply to condo facilities or amenities. So next we looked at Section 20, Schedule 2 of the regulation, which addresses recreational amenities and requires that they be closed. Again, there's no definition of amenities and no reference to a place, business, or facility. We question why this would not apply to condos. Surely, if the intention was to exclude condos, the government could have carved out the exclusion in the legislation, or at least specified which amenities the regulation applies to. Unfortunately, the government has been consistently inconsistent in its drafting of COVID legislation, which is meant to provide guidance as to what restrictions are in effect and to which businesses and places they apply. Ultimately, Ontario entered this modified Step 2 in response to the continued spread of the Omicron variant and concerns about hospital capacity. In our view, the purpose of the legislation is to reduce transmission of the virus in places where people will be congregating. The government's focus has always been on higher risk indoor public settings where face coverings cannot always be worn. With this logic, there is no difference between public and private amenities, such as a commercial gym and a gym in a condo. So despite the statement issued by the ministry, we are of the opinion that OREG 26320 should apply to condos. While we agree that condos should be able to impose higher thresholds than the legislation requires, they shouldn't be allowed to fall below the standards in the legislation. Also, Section 117 of the Act puts the onus on condos not to permit a dangerous condition to exist. Condos should be very careful and thoughtful about not falling below the standards set for the public. Otherwise, an owner or resident could consider the same to be oppressive. So Shannon, I'm gonna pass it back over to you.
Perfect, thank you. So as we have mentioned throughout, there still remains much confusion. In response to the Ministry of Health statement on January 10th, the City of Toronto also updated its COVID-19 guidance for commercial and residential buildings, advising that the regulation does not apply to condominiums that are not public settings and are intended for private use. However, the city added that it strongly recommends that all condominiums close non-essential common areas, including but not limited to gyms, pools, and other high traffic areas. The updated guidance from the city does not change our opinion that the regulation should apply to condominiums. And in fact, it further supports our argument that there should not be a lower standard for those facilities that are public and those that are private if reducing the transmission of the virus is the intended goal of the legislation. So I'll now pass you over to John, who will be presenting two recent COVID-19 cases.
Thanks, Shannon. So we had in March of 2021 our first real court decision concerning condominium corporations and the requirement to wear masks, and that was in the Mitrovic case, which we've presented on before, but Halton Condominium Corporation number 77 in Mitrovic. And that was really two separate court proceedings. The first was an injunction where the condo sought to have the unit owners immediately required to wear masks on the common elements, pending a determination of the actual merits of the application. And the court on the first appearance said, yeah, you have to wear your masks. On the second appearance, which was a more fulsome argument based on the affidavit evidence that was submitted, the court took a very strange sort of approach to this, and the judge felt the need to balance both the rights of the unit owners and the rights of the condominium corporation and the residents and occupants of the corporation. Not to say that that was necessarily wrong, but the decision that came out of Mitrovic was the unit owners were required to wear masks only when they weren't taking the most direct method of ingress and egress from their unit. So the court, in making that finding, said, yes, COVID-19 creates a dangerous condition that the corporation is obligated to prevent under Section 117 of the Act, and that the failure to wear a mask can be inducive to spreading the disease, and you can get the disease. And yes, we acknowledge it's dangerous, but only when you're not taking the most direct method to either enter or exit your unit. So very strange balancing of the rights there. And the court didn't really go into much by way of assessing the evidence that was led by Mr. and Mrs. Mitrovic. The court said, well, there's this Burlington bylaw that exists that says you can't ask for evidence of a medical condition. You just have to accept it at face value. And there's really no medical evidence led other than to say, I have difficulty when a mask covered my nose. So we have that decision that came out, and leading to sort of many questions. Well, what is the actual direct right, and how does this apply in a condominium corporation generally? And what if the building itself has a high number of at-risk individuals, etc.? And then we moved on through that into a case out of Ottawa that we've come to know as Yakovlev. And Yakovlev, slightly different facts, but there was no real allegation that there was a medical condition that precluded the unit owners there from wearing masks. And in fact, the unit owners sort of admitted that, you know, we don't really have a medical condition. I need to take my mask off when I'm eating, and I have a stomach condition, so I have to eat many times during the day. Sort of question whether that, you know, was actual medical evidence or not, but the court didn't go into that. The court simply said, yeah, you're required to wear a mask, and issued the order under section 134 of the Act requiring the unit owners to wear masks when on the common elements. And the court in Yakovlev reinforced the fact that COVID-19 and the not wearing masks is a dangerous condition. There's been a few cases that have followed that track and have not really deviated from Yakovlev in any substantial way. Megan from our office and myself had one fairly recently in YCC 794 and Watson. And again, the court didn't ask for a lot of submissions on whether or not these individuals were wearing masks. They simply said, okay, it's in the affidavit evidence that they're not wearing masks. Okay, ordered to wear masks. So we find the willingness of the court to find that there's a dangerous condition with the mask and to impose a requirement for unit owners, occupants, residents, guests, etc., to wear masks on the common elements. Thank you.
Perfect, thanks, John. So since the beginning of the pandemic, there has been a number of new policies that condominiums have implemented to protect their communities, including mask policies, amenity policies and waivers, and proof of vaccination policies. The City of Toronto announced in July 2020 that all condominiums in the city must adopt a face mask policy by August 5th, 2020. Since then, many other regions have also adopted a similar bylaw, and as such, most condominiums, if not all, now have a policy in place. The policies must provide that the masks or face coverings are to be worn when on any indoor portion of the common elements. And it's important to remember to note within the policy that some individuals may have reasons for not being able to wear a mask or a face covering. Some individuals that may be exempt from wearing a mask are children under the age of 2, anyone who has a medical condition that inhibits their ability to wear a mask, anyone unable to put on or remove their mask without assistance from another individual, and any individual who is being accommodated in accordance with the Accessibility for Ontarians with Disability Act, or any individual who is being reasonably accommodated in accordance with the Human Rights Code, sorry. In addition to the mask policies, some condominiums have also implemented vaccination policies that apply to all indoor common element amenity users, as well as on-site employees and contractors. With this, it's also recommended that condominiums implement both a human rights policy and an information management and privacy policy to reduce its exposure to potential liability under the Ontario Human Rights Code and to protect the privacy rights of individuals. Remind you that condominiums continue to have authority and the ability to adopt vaccination policies requiring residents and or visitors to show proof of vaccination in certain settings. With the current Omicron variant, confirming vaccination status when accessing non-essential amenities is a reasonable precaution to ensure the safety of those using those amenities. The pandemic has also caused the use of technology to accelerate at an unprecedented rate across various industries worldwide. What initially began as a requirement to ensure deadlines were met and normal operations could resume, the transition from in-person meetings to virtual AGMs has been embraced by many organizations. In many cases, virtual AGMs have now become the preferred method for conducting an AGM. Conducting an in-person AGM can be rather costly, and for those who have a history of a low turnout, these costs can increase significantly if quorum is not achieved on the first attempt. AGMs held virtually are often a fraction of the cost as those held in person. Also, virtual AGMs provide participants with the ability to attend meetings from the comfort of their own home, and this increased level of accessibility often translates to a significant increase in participation. Looking forward, many condominiums are now looking at conducting hybrid AGMs, which is an AGM that has both in-room attendees as well as remote attendees who participate via a virtual meeting platform from the comfort of their home or anywhere worldwide. This offers flexibility to participants who can opt to join the meeting online or attend in person. Thank you, and I will pass you back over to Patricia.
Very much, guys. That was a great overview. And I think even in the case that John was talking about, the corporation there did have a mask policy. So I think that's as well where the places where our policies also butt up against, you know, our compliance applications and evidencing what the standard is for the corp. The other thing is we also have to remember that under Section 117, we have an obligation to ensure that a dangerous condition doesn't exist. And that can't be lost in translation here. But at the same time, I appreciate the difficulty that condos have in trying to ensure that things are consistent and consistent with the legislation that surrounds them. So we have a couple of polls for you. And we wanted to ask you, does your condo have a virtual meeting bylaw in place? I know that the legislation timeframe has been extended, but we're curious to see where those numbers are. Okay, let's see. Okay, maybe we can, numbers are still changing. Okay, I see that 38% yes, do have it, and 62% polled do not. Now, here's the thing. I think there's an opportunity here, and it might be wise for the corporation to control the parameters around how this bylaw works for your corporation. Can we have the next poll? In 2022, will you hold your corporation's AGM in person, online, or will it be a combination of both? 100% so far. Okay, let's see. Okay, all right, so we have, we could close that poll. 6% telling us that they will do it in person, 71% online, 23% a combination. Those are great results. I mean, I echo that the convenience and speed of virtual meetings and even the numbers of attendees is fabulous. But it's interesting to see that people want to go in person. And that's a unique feature about condos. I've done quite a few in-person meetings in my day, and I can see us wanting to get back there, but I also see an interesting growth here in the combination of both. So we're looking at hybrid. And I think this is where the bylaw presents an opportunity to define some parameters around how that can work. And our third poll is, do you think a hybrid meeting will be effective for AGMs? And if we could run that poll, that would be great. And if you have any idea what the problems might be, we would appreciate hearing from you on what you think those might be. I don't know if that poll is running. I can't see it on the screen. But maybe we can come back to that if we can't get that running. We can jump to the next slide. So Julia, if you want to talk to us a little bit about the merits of the virtual or electronic meetings bylaw, that would be great.
Thanks, Patricia. So the Ontario government has extended the deadline for condos to be permitted to hold meetings virtually without a bylaw in place authorizing them to do so. The previous deadline of December 31st, 2021 has now been extended to September 30th of this year. So this is good news for the time being, but condos should still be thinking about the future beyond the pandemic. We recommend that boards take the time to implement a bylaw that permits both virtual meetings and electronic voting. Such a bylaw will allow the condo to hold owners' meetings for the duration of the pandemic, but will also provide owners with more flexibility after restrictions ease and the pandemic eventually comes to an end. So since the beginning of the pandemic, virtual meetings have increased owner participation because they allow people who are stuck at work, traveling, non-resident owners, those with mobility issues, or those who would just prefer to attend online to easily participate in the meeting from the comfort of their own home. As for e-voting, it offers more flexibility, allowing owners to easily vote even before the start of the meeting, and provides the condo with instant and reliable voting results. The purpose of implementing a new bylaw is so that you can continue to hold electronic meetings, but also you can control the content of the bylaw so that you have flexibility to hold electronic, in-person, or hybrid meetings, and set the parameters surrounding each kind of meeting, including the procedures for registration, attendance, and participation. So we would encourage everyone to speak to their legal counsel about drafting and implementing an electronic bylaw. The bylaw should, again, at a minimum, address virtual meetings and electronic voting. Virtual meetings are the way of the future, or at least a hybrid model, and condos should be prepared to continue with these kinds of meetings and ensure that they have the authority to host them. Proposing this bylaw now is ideal because the reasoning behind it is fresh in everyone's minds. So Patricia, I think I'm going to pass it back to you.
Yeah. Can we have the next slide, please? And you know that we've been stressing that through the year, and we wanted to highlight from 2021 some of the issues that were at the forefront. And for us, COVID obviously was part of our ongoing dialogues, but we explored topics like passports, and we've seen now how passports have been implemented, and how passports have also been motivators for people to get their vaccines. We've talked about masks and how they are important in avoiding the transmission of the disease. And as well, we've talked about reopening and closing amenities. Insurance was a big topic, and it has been a big topic for several years now because the market was still hard. And that meant that condominiums throughout Ontario and really across the country have actually experienced increases in premiums, deductibles, and trying to even access insurance has been difficult for some condominiums. So we've been working actively with members in the industry through organizations like CCI to try and come up with ways to manage these risks so that they translate back to better insurance quotes and premiums for corporations. Electric vehicles came up again, and I think with the climate change discussion really being at the forefront globally, condominiums are well advised to explore the expansion of their resources to accommodating electric vehicles. The Act, as you know, does provide for the ability for a unit owner to ask for it and for the corporation to be required to provide it. The Miami condominium collapse obviously was a huge tragedy in 2021. It highlighted that we cannot bury our heads in the sand, that we cannot ignore data that's in front of us, and we should not be sidetracked by dialogues that with unit owners who are questioning the cost. This condominium showed problems right from the beginning of its I guess, incorporation. There were issues that should have been addressed. There should have been for inspections, and there should have been actually an order to evacuate from this building. Chargebacks, we did a really excellent CondoWise presentation on chargebacks and how they work. Our bottom line is make sure your indemnity in your declaration is good enough to cover what you need to be interpreted as a chargeback. Construction lien process, we also did a presentation with Justin Tudor from Keller Engineer and John. They talked about the lien process and how to deal with that new process. Aging in condominiums is going to be an ongoing issue, and we talked about that quite a bit last year, as well as the decisions of the CAT regarding records. As the CAT expands its jurisdiction, it's interesting to see where condos are actually investing their resources, time, in terms of going to the CAT and having to defend or even further their position with unit owners. And it's all good. There's a lot of content here. And even on hybrid meetings, we at CondoWise had done a presentation on that. And I'm happy to say that everything is available to you in our YouTube format. So you can always go back and watch the discussion on any one of these topics. So moving forward, after we've looked at the past, we're going to take you into a case law update. Next slide, please. And so I'm going to hand it over to Julia and John to take us through some of the cases that we should be thinking about and how they impact us.
Thanks, Patricia. I think this one starts with me. So one of the cases that sort of emanated out of 2020 was the Amlani decision that caused a bit of a stir. On sort of first look at the Amlani decision, it seemed to, on a very quick read through, seemed to imply that no chargebacks could be added to a unit's common expenses without first having a compliance order given by the court. A lot of people that were opposing liens then started throwing this case in our face and saying, you can't do this, here's the Amlani decision, you can't do it, you can't do it, you can't do it. What Amlani did was say that the wording in the declaration, which everybody knew was the turning point, the wording in the declaration has to actually support what you're trying to do. And we just heard Patricia talking about that a few minutes ago when we talk about the lien process. So this year, when O'Regan came out, O'Regan involved smoke damage to a unit after an owner had left, I believe it was eggs cooking on the stove. And the owner was then charged back the deductible under the insurance deductible bylaw, but also pursuant to the provisions of the Act in relation to repairing the damage. When the court did this and charged him back, this was challenged and the resulting lien was challenged. And the court in O'Regan looked at the provisions in the indemnity, looked at the Act and said, yes, there are certain things that you can charge back for without a court order. You don't need a court order for every single chargeback. If it's provided for in the declaration, you can charge back. If it's provided for in the Act, you can charge back. And this highlights the fact that a proper declaration, a very well thought, crafted indemnity provision is key to allowing you to recoup your costs without having to worry about, you know, do I need to push this the whole way to get a compliance order to make sure that we're fully indemnified for our costs? And that's more important now when we look at things that are being pushed into the Condominium Authority Tribunal. And the Condo Authority Tribunal doesn't have the general right to award the condominium corporations or any party their full costs. So when we're pushing things through to the Condominium Authority Tribunal and looking at the outcomes that we're seeing on a regular basis, we're seeing, you know, not inexpensive applications going through to their conclusion, the condominium corporations being successful, but yet the condominium corporations are left holding the bag. They have the legal fees to pay, they're out of pocket, and the Condo Authority Tribunal is not reimbursing the condo or indemnifying the condo through the owners for their efforts. O'Regan also confirmed that the 3-month deadline to lien a unit starts after a default has occurred, and states really what was trite law, but for some reason it needed to be stated again, that there's no default until a demand for payment has been made. So if you have something that has not happen. So for example, you have a fire in the unit, you've got your deductible insurance bylaw, you charge back $50,000 because that's the lesser of the deductible and the damage amount. But you do that 6 months after the fire, and the unit owner comes back and says, well, no, my lawyer said you can't do that. You're supposed to do it within 3 months of the fire occurring. Well, we have O'Regan again that says, no, until you demand the money, until that demand time frame has passed and you say the money has to be paid by the 20th of January. And the 21st of January, it's the first day of your default. That's when your lien period begins to run. So that was O'Regan. What have we got next? I believe we're throwing this back to Julia for a second now.
This is me. Okay, so the next case, Tscc 1628 versus Pscc 1636. In this case, the two condos were party to a cost-sharing agreement, which included an arbitration clause that said any dispute that arises under the agreement is to be determined by arbitration. So the parties had a dispute regarding the amounts owed under the agreement. Parties went to mediation, mediation failed. One of the condos then tried to arbitrate the agreement, but the other condo didn't think arbitration was appropriate and commenced an application to Superior Court seeking various relief, including an order that the conduct of the other condo was oppressive under Section 135 of the Act. The other condo then brought a motion to stay the application in favor of arbitration. The motion judge dismissed the motion and found that the entire matter should proceed to court. The decision was then appealed to the Court of Appeal. So the Court of Appeal did not agree with the motion judge and said that the core of the dispute was the interpretation and application of the cost sharing agreement, and that these kinds of disputes required mediation and arbitration under Section 132 of the Act. The Court of Appeal also disagreed with the motion judge that oppression claims can only be determined by a court, and said that such claims may be determined by arbitrators if the claim relates to a dispute that falls within the terms of the arbitration clause or Section 132 of the Act. So the language of Section 135 is therefore permissive, not mandatory. In this case, the court held that because of the broad language of the arbitration clause, there was nothing that would prevent an arbitrator acting under the authority of that clause from considering the alleged oppressive conduct. So the court granted the stay and the two condos were to proceed to arbitration. The takeaways here are that oppression claims can be determined by arbitrators if the claim relates to a dispute that falls within the terms of the arbitration clause or Section 132 of the Act. But not all cost sharing agreements will have such a broad interpretation clause arbitration clause. And if they don't, the parties may not be required to proceed to arbitration. So it will be fact specific and depend on what's written in that arbitration clause. Next slide, please.
And that's back to me. I do want to just comment on Julia's slide there. What's coming out of the Superior Court more and more often now is they don't want to have to deal with condominium disputes. They don't want to deal with unit owner disputes, compliance applications, unless they're in the most serious of matters. It's not that the court doesn't want to deal with it. There's this sort of apparent overriding principle that unit owners and the condominium corporation should all live in harmony, and that they should all work together for the good of the community, et cetera, et cetera, et cetera. The requirement to mediate arbitrate when you put a dispute into mediation and arbitration can lead to the same remedies that a court can award. And there's often a hesitancy to go to mediation and arbitration for various reasons. Sometimes it's a cost concern, sometimes it's because you have to pay an arbitrator. But what we're also seeing is, with the case law that's coming out of the Superior Court, compliance applications that have already been started before the case law started coming out are now being challenged at interim stages of the applications and right through to the steps of the courthouse for final decisions and final hearings. The decision to mediate and arbitrate now is, or should be, on the cards for the vast majority of condominium disputes. The decision not to mediate arbitrate, if it's met with some kind of rebuttal by the unit owner or whoever it is you're dealing with, can have significant cost consequences. When you push an application through to its final stages and your costs are at $25,000, $30,000, and the unit owner comes out and says, "Hey, you're supposed to mediate arbitrate this. Well, we want the judge to kick this out." I had one of these hearings on Friday of last week, where we're now waiting on a judge to determine whether or not a attempt to kick a matter back into mediation arbitration at the last minute is an appropriate way of doing it. There are carve-outs of the Arbitration Act to say you can't leave it to the last minute to determine whether or not a matter should be mediated or arbitrated. You're supposed to move without undue delay. So that's going to be an interesting decision that's coming out in hopefully the next few weeks, and maybe shape some of the compliance applications going forward. But in terms of York Region Condominium Corporation 794 in Watson, that was another case that Megan and I had from our office, involved some nuances of the law in Section 134. Section 134, being the compliance section of the Act, allows the court to really craft any order necessary to bring about compliance. with a few exceptions. One of those, you can still have the compliance, but under section 134, where there's tenants involved, the tenants, no matter how bad their conduct, you can't kick them out of a unit on the first attempt. That tenant has to have a compliance order issued against them and has to breach that compliance order, putting them in a contempt of court for all intents and purposes, before the court will then entertain evicting them from the unit. In this particular case, Miss Watson was the owner of one of the units. The occupants of the units were her daughter and her granddaughter. The conduct of the occupants of the unit included creating noise through all hours of the evening, approaching other residents, threatening bodily harm, yelling obscenities, racial slurs, homophobic slurs, sexual slurs, all sorts. Defamatory material was left around, voicemails, harassing and threatening emails to the staff. Death to you was one of the favorite phrases that was used, all sort of indicative of severe mental health issues, but also issues under section 117 of the Condo Act, where the condo can't allow dangerous conditions to exist. And our position was that telling somebody, death to you and you're going to die and you need to be held accountable for all your crimes was a dangerous condition. The court agreed. The court agreed that there's a dangerous condition, and we asked for them to be evicted on the first instance. Knowing that going in, we had the provisions of section 134 that's, candidly say you can't evict a tenant on the first opportunity. There were some issues with respect to, well, actually, are they tenants or are they something else? The unit owner's lawyer in this particular case said through correspondence to our office, they're not actually tenants, they're beneficial owners. They hold a beneficial interest in the property. And really, I can't take any steps at the landlord-tenant board to evict these people because they're not tenants. So we put that before the court and said, look, Your Honor, we have this letter. Section 134 does say this, that you can't evict them if they're tenants, but they're not tenants. And we're going to ask that you evict them. The court agreed. The court said they're not tenants. There is no evidence of a leasehold interest in the property on part of the occupants. Court agreed that the conduct was severe and allowed that there may be some indications of mental health concerns. There was no evidence of that before the court, and that the attempts to bring about compliance through our office had gone on for, I believe, over a year. So there was significant attempts to bring about compliance sort of with the reasonableness requirement that the court has occasionally brought forward as being an issue in these types of matters. So we had the reasonableness, we had the lack of evidence of an occupancy, and we have or a leasehold interest, and we also had the conduct, and the court agreed that the unit owners, the occupant should be evicted and awarded the condominium corporation its full costs. And next slide, please. I think that's
Okay.
Julia.
Yeah, so the next case is Lozano versus Pscc 1765. So in this case, damage was caused to the common elements when the unit owner's toilet overflowed. The owners were actually out of the country at the time. So the court charged the cost of damage back to the unit under section 105 of the Act, and a bylaw that had been passed by the court, which said that the owners were responsible for damage to other units and the common elements in the event that an owner or a person residing in the owner's unit caused the damage through an act or omission. The damages in this case, which I believe were around $10,000, were less than the deductible limit of the corporation's insurance policy, so the owner was responsible just for the cost of the damages. The judge held that the damage in question resulted from the owner's act or omission, even though they weren't necessarily negligent. So they were aware that the toilet had previously malfunctioned and chose not to bring a plumber in to address the problem. Also, while they were conscientious in arranging for family members to come and check on the unit while they were away, they didn't take steps to shut off the water. And the court said this would presumably have mitigated against the damage suffered here. The court also said that these were omissions for which the owner should be held responsible. So the owners appealed the decision. The divisional court agreed with the judge, in part finding that the failure to hire a plumber may not qualify as an act or omission, but the prolonged absence and their failure to shut off the water did. So the court found that proving causation by an act or omission does not depend on a finding of negligent behavior, and that the reasonableness of a unit owner's conduct is not mentioned or alluded to at all in Section 105 of the Act. What matters is whether they have done or failed to do something that then caused damage to other units or the common elements. So the reason behind this is that placing too high of an onus on a condo to claim reimbursement for deductible or damage expenses would allow individual owners to offload their financial consequences of damage caused by their inactions or actions onto the court and thus to all the other owners as a whole. So the appeal was dismissed and the owners were responsible for payment of the damages. John, I think back to you for one last case.
Yeah, I just want to touch on this one very quickly. I know we're sort of running out of time now. That's Pscc 12 and Gill, and this was a hoarding case. And the reason I wanted to just briefly mention this case is it was obvious hoarding issues. The condominium corporation had brought in FCS, a sort of fire consultancy company, and they looked at the material in the unit and they found that there was a lot of combustible material in the unit. The court agreed that this combustible material created a dangerous condition under Section 117. And the condominium corporation had been trying, again, very sort of gently and reasonably to try and bring around compliance and to have the unit owner remove the combustible material. The one thing that really struck me with this particular case is that the condominium corporation actually hired or offered to hire on behalf of the unit owners a hoarding support coach through the Canadian Mental Health Association. I thought that was very interesting, in that the fact that courts are often looking to see the condominium corporations in these type of matters acting reasonably, especially when they're asking for, in some instances, $20,000, $25,000, $30,000 of costs. And then you're faced with having to award these costs against somebody that has a very obvious mental health concern. And the court in this particular case did award a high amount of costs. I believe the amount was $25,000. And I believe it was done in part, if you read through the case, because the condo had taken all these necessary steps and they have the ability to do that under Section 134. So even when you're faced with these mental health concerns, litigation is, maybe the ultimate path that everyone goes down because the compliance is difficult to obtain. But there are other mechanisms out there that could maybe be explored before the cost of mediation is incurred. Again, the court looking to try and resolve all these disputes as quickly as possible with the least amount of expense to all the parties, but also taking into consideration all the circumstances. Thank you very much. I think that's all I have to say.
So looking forward, I have to tell you about the future. It's going to be an interesting year. I think affordability and agency rights and are all the things that we need to consider. Yesterday, the federal government had the Senate on affordability housing. So it's not just about affordability. It's about affordability. And we've got Congress of really passed and accumulated budget line items. In terms of really an ongoing issue, and as I've mentioned through CCI, we are making submissions that were at the deadline was January 31st. If you'd like to make your submissions on your experiences with insurance, and I think that is what's really important that the government can hear from you. And it's really out of this, and as you may know, there are rebates available to condos that can invest. There are companies that will help these applications. We recently, last year, did a presentation with.
Sorry, Patricia. I think we're having a few people saying they're having difficulties hearing you. I'm not sure whether your microphone is a little bit muffly. No.
No.
Can you hear me now?
Yes.
Yeah. Okay. Thanks for letting me know. So, in terms of affordability, I think it's going to be an ongoing issue. Electric vehicles, the important point is there are rebates available for corporations. Maintenance and repair is going to be an ongoing discussion because of the Miami condo, and we're going to hear more about the results of those pieces of litigation. Control of the common elements, as you can see through COVID and even the legislative policy, we need to get it straight. We need consistency in our policies. But I would suggest that condos actually drive that, set the standard for your community, because the courts most of the time will support the boards and enforce that, but do it in a way that it's a rule, because rules can be enforced through compliance. Awarding of legal cost is going to be an issue in the industry, because as the CAT's expansion continues, and there is no provision for the providing of legal costs, because I think there's a danger here that advocacy is not valued. You know, that's another cost that's getting downloaded onto unit owners. And I think we really need to be cognizant of that. It's not fair to ask condominiums to go ahead without advocates. It's not fair to ask unit owners to go ahead without advocates. There should be an opportunity, though, for the condo, for example, to be reimbursed for its costs. And you should let the government know that, because the Condominium Act is drafted in that way. That is the power of 134. The power of 134 is that you can get an order to charge back all your costs. To diminish the value of advocacy is to undermine condominiums. It is going to be an escalation of dispute as well, because there is no cost to engaging in CAT disputes. So the condo, if you think about it, could be actually investing a lot more resources because disputes will be more frequent. I highly encourage, and those of you who know us at Aaliyah Associates, we encourage de-escalation. We have invested so much time and in our own practice to try and mediate, to try and find alternative ways of understanding what the conflict is and working, because you're in community. And so these people, you know, everybody's passing each other in the halls. They're your neighbors. You don't want to be in conflict, but sometimes it's inevitable. But the point is, should all the unit owners who are not causing the conflict, who are not escalating the dispute, should every unit owner pay for that? You know, for myself as a condo owner, I don't think that's fair. For myself as a board member, I want to make intelligent decisions, and I want counsel to help me understand what my obligations are, because I personally don't want any liability. I want Section 37 to protect me. As we move into the future, shared facilities agreements, you need to make sure that those are drafted in such a way that if you're going to use mediation and arbitration, that you've really thought through what the arbitrator's powers are going to be. This whole dichotomy between oppression claims being heard by the arbitrator, one of my real concerns is arbitrators are not judges. And sometimes I think we're getting it all confused. I think we think tribunals are courts. They're not. Tribunals are organizations that are created by ministry policy. They do not have the distance and discretion that courts have, but they also don't have the same powers. They only get their powers from statutes. Same with arbitrators. They should be getting their powers only from the agreements. So your shared facilities agreements should be clear. Your arbitration and mediation bylaws should be clear on what the scope of responsibility and authority is going to be. And this is where I find the interpretation of the act problematic. I understand courts pushing condos out. They probably appreciate there's a tribunal, and there's probably a strong urge across all courts to say, go to the tribunal, go to arbitration. But the point is this: neither the tribunal or the arbitrators have the same powers as the courts. And sometimes you may need the powers of the court. So how do you affect those? So careful drafting and shared facilities agreements is going to be an ongoing issue. Nuisance at the CAT, imagine condos without any nuisance. That's impossible as long as humanity is thriving in condos. So we are going to see an escalation of CAT disputes. And I'm hoping that the process de-escalates things quickly, that mediation works when it is appropriate. But breaches of the act are not required to be mediated. And I think we need to always be clear about that. So make sure your rules are being updated to stay current, that your declaration has a good indemnity provision. And these are all things you can put on your agenda for your board this year. And it'll take time, obviously, to pass them, obviously time to think it through, draft them, work with your professionals to make sure that you're not over prescribing as well. But at the same time that you're finding that balance in the new environments that we find ourselves in. So we did have some comments in the Q&A, and I really appreciate you taking the time to provide your comments. So there was one question. So at this time, Condo should be going ahead with annual in-suite services such as pest control and fire detector checks? Yes, absolutely. There should be no stoppage of these kind of essential services, especially the fire smoke detector checks. Why? There are more of us at home. There is an increase in fires. If you heard from Michelle Farley over at FCS Fire Safety, she's a member of CCI Huronia. She has confirmed that there are increases in fires. So it is good for the corporation to show that the record shows that they did the work. There's a comment here, virtuals are great for younger generation, but condos with older populations lose attendees due to lack of access to technology. Totally understand that comment and appreciate that, which is why I don't see the in-person meeting dying. I see, people wanting to get back to that phenomena, but I can also see that if we can master the hybrid, that we're going to do better. Why go through the expense of a bylaw for virtual meetings? Considering its popularity, isn't it likely that it'll be permitted beyond September? Yeah, I think you're right, John, but I think the value of the bylaw and the beauty of the bylaw is that you can actually think through the whole architecture. Condos do not have the ability to act beyond the powers given to them under the Act or their bylaws. So if your bylaw is robust and fulsome and allows for hybrid, allows for that kind of participation, then the board has guidance, so does property management, and so does the community. What do you suggest when owners can't be reached and the smoke detector can't be checked? That's a great question, but I think you have a right of access under the Act, and I think you should rely on that. Your bylaws probably also reinforce that right of access. So put the unit owner on notice, make sure you have security with you, and you go and do the smoke detector check. It is really essential because there have been fires where there has been loss of life in multi-stories, and it could have been avoided. The reason in one of the most predominant historical ones was that somebody had disconnected the smoke detectors. And, I think a young child's life was lost. And there's no tolerance for that when you put life safety at jeopardy. So thank you again for being with us. Thanks for participating. Thank you, John, Julia, and Shannon for helping us out on these topics. Very robust content, and we appreciate that. And Justine Jones of our team is also in the background under the Aaliyah Associates logo. So thanks, Justine, for helping us out. And we'll see you at the next one. So take care and be well.